Hey guys, quick video while the coffee's brewing. The Richard Allen confession. The filings made public in the Richard Allen case indicate that he has confessed, particularly to his wife, that he committed the murders. This was on a call made from a jail phone. And since she terminated that call made in April, apparently he's not called her or anyone else since. The question here is whether this kind of statement is admissible. The answer is yes. A statement made by a party opponent, and Richard Allen is the party opponent in this case, is defined as not hearsay under the Indiana Rules of Evidence. 801. Now this kind of thing you'll see around the country is why you sometimes see the jailhouse snitch being able to testify, or someone who knew the defendant before the arrest saying, he told me he did it, or whatnot. So yes, it's generally admissible. Now the defense may try to exclude this evidence by motion in limine, saying he was babbling incoherently, or something like that, but that's unlikely to succeed. Most likely, as they appeared to concede during a related motion hearing, is that the jury's going to hear these statements. If the defense can, it would try to mitigate the impact by trying to get in some evidence of his mental state at the time. But the jury, barring something unforeseen, will hear this evidence if it goes to trial. In addition to being potentially major evidence, this also matters regarding circumstantial and direct evidence. As we've discussed, the law does not say that circumstantial evidence, cell phone tracking, DNA, is weaker than direct evidence, eyewitness testimony of the crime, for example. The jury decides the weight of the evidence. But, as we also discussed, if the case is totally circumstantial, the defense can request an instruction that the circumstantial evidence must foreclose other reasonable theories of evidence on top of the reasonable doubt instruction. It may not change anything with the jury, but the defense wants every tool it can get, and that's fair. But this instruction doesn't really apply when there's direct evidence, because then the case is not wholly circumstantial. And guess what? A confession is direct evidence. It's a person saying they saw the crime and from his own personal knowledge knows the identity of the perpetrator, himself. This has been stated more than once by Indiana appellate courts, with the courts flat saying a defendant's confession of guilt to another person is direct evidence. Now, of course, the weight of a confession or admission against interest placed into evidence, like all evidence, that's up to the jury. They find it persuasive, important, or whatever, that's their job. On that, while one can imagine being highly skeptical of, say, a jailhouse snitch, or even the remembered statement of some acquaintance that occurred long ago, the game changes when it's a recording of a conversation with one's family. Again, the defense will attack this, for sure, if this goes to trial, but you can bet 100 times out of 100, defense counsel would prefer not to have to deal with a recorded confession by their client to one or more family members for reasons that ought to be obvious. Well, that's it. Thanks, bye.